Masechet Baba Kama Daf Ayin Aleph. The Mishnah mentioned that if a thief steals an ox and then sells it on Shabbat, he has to pay 4 and 5 because selling on Shabbat is not a biblical violation. There's no death penalty there. This is in contrast to if he steals it and then he slaughters it on Shabbat, then he is liable to capital punishment for violating Shabbat. And since he's liable to capital punishment, we can only give him the harsher punishment. He gets only capital punishment, and he does not have to pay the fine of 4 and 5. That was on Shabbat. However, on Yom Kippur is different. If he steals it and then slaughters it on Yom Kippur, he does have to pay 4 and 5 because there's no capital punishment for violating Yom Kippur. One gets karet or lashes. Since there's no capital punishment regarding Yom Kippur, so he does have to pay the fine in 4 or 5. All right, that's what we learned from the Mishnah. Now we ask, Amri, Amai, nihi diktala leka malkot mihaika v'kaimalan de no lokeo mishalem. So why should he have to pay for slaughtering on Yom Kippur? Even though there's no capital punishment, still he gets lashes, and the rule is that one does not get lashes and pay, right? We apply the no double punishment, not only to capital punishment and payment, but also lashes and payment. One cannot get both. So even though Yom Kippur is less severe, still, since he gets lashes, we should say he's patur and should not have to pay. Amri Hamane Rabbi Meir hi damar lokeo mishalem. So our answer is that actually this Mishnah is the minority opinion of Rabbi Meir. Rabbi Meir thinks that one can get both two punishments, both lashes and paying. This is only the opinion of Rabbi Meir. You're right, the other sages would say if you get lashes, then you don't have to pay. Wait a second, if this Mishnah is Rabbi Meir thinks that you can get two punishments. He even thinks that you can get capital punishment and payment. So therefore, even if it was slaughtering on Shabbat, which is Asur Midoraita and gets capital punishment, if it's Rabbi Meir, he would say, well, then you get capital punishment and you pay 4 and 5. But the Mishnah, we're going to see the Mishnah later on, contrast with this Mishnah, our Mishnah that we saw above, says if he sells it on Shabbat, then he has to pay. But we're going to see the follow-up of the Mishnah says, if he slaughters it on Shabbat, then he doesn't have to pay. But if it's Rabbi Meir, then he should have to pay, even though he's getting capital punishment. And maybe you'll say, no, Rabbi Meir only thinks that you get two punishments if it's lashes and payment. Then yes, those can both apply. But capital punishment and payment, that even Rabbi Meir would agree that you don't get those two. But that's not true. Velo v'hatanya ganav v'tavach b'Shabbat, ganav v'tavach la'avodah zara, ganav shora niskalu tvacho mishal marba v'chamisha divrei Rabbi Meir hachamim potrim. Look at this baraita. In the case of a thief who steals and then he slaughters on Shabbat, or he steals and then slaughters the animal for the sake of avodah zara. These are the two that are important for us right now. In both of those cases, he has to pay 4 and 5, even though both of these are capital punishment. Slaughtering on Shabbat or worshipping avodah zara by slaughtering an animal to it, these are both capital punishment, and Rabbi Meir says that he has to pay. So you see, Rabbi Meir does not have the principle of kimle b'drabamine. He says if you're liable to two punishments, you get both of them, whether it's lashes and payment or even capital punishment and payment. Hachamim say no in these cases because, right, you don't get two punishments. Okay, we're going to have to come back to the Shor HaNiskal. Shor HaNiskal means an animal that committed some a murder or a terrible sin, and then is found guilty, and so then this ox itself is supposed to be slaughtered. This ox, no one can get benefit from it. If, let's say, has to be stoned. If someone, before it's stoned, decides to slaughter it, it's not kosher. You can't eat the meat. You can't benefit from the meat. You can't benefit from the animal at all. So if a thief steals an ox that was sentenced to be stoned, technically it's not owned by anyone because it has no value. Since you can't sell it, you can't use it. It's not actually owned by the original owner. So what does that mean that he's stealing it? Whose ox is he stealing, and whose ox is he slaughtering? So we're gonna that would be why Chachamim say you don't have to pay. We're gonna discuss why the Bimei thinks that you do have to pay, that the thief does have to pay, even though he's slaughtering something that doesn't belong to anyone. Anyway, we'll come back to this, but this is not. This doesn't fit into the capital punishment scenario of the first two. But our point here is that Bimei thinks that one is liable to pay and get capital punishment, and therefore, if our Mishnah is the opinion of the Bimei, then we will not be able to understand the Mishnah, because the Mishnah says that Tavach b'Shabbat is patur. So what are we going to do? Amri bar mina dehi dehait marala amar bi Yaakov amar bi Yochanan v'amri la amar bi Yirmiyah amar bi Shimon ben Lakish Rabbi Abin v'Rabbi Eliyahu bechol haburata mishmed Rabbi Yochanan amre betobeach al yedei acher. Oh, so it says bar mina dehi, right? Take this baraita and take it outside, right? Don't interpret it at face value. We're accepting that the Braita is true, but we're limiting it to a case. This is in the name of many different tradents, but ultimately in the name of Rabbi Yochanan, who says that this whole Braita is talking about where the thief doesn't do the shechita himself. He takes it to someone else. He takes it to the butcher and asks the butcher to do the shechita on Shabbat, and therefore, the thief is not liable to capital punishment because he's not the one that did the shechita on Shabbat. So the case would be a thief stole it, and on Shabbat he asked a friend, "Would you mind doing shechita?" The friend is liable to capital punishment. If someone asks you to violate Shabbat, you still can't do it, and you'll be liable for doing it. So the friend is liable to capital punishment. The thief is not liable to capital punishment. Therefore, the thief has to pay. So this is, in fact, the Bimei thinks he has to pay because of that. But the Bimei would agree that if the thief did it himself, he would not be liable. And so to be a Meir, in fact, does have the principle of Kim Le'ebed B'Mineh, and he applies it. He applies it to capital punishment and a fine. You would not get two punishments. Rabbi Meir, however, does not apply kim le'b'mineh if it's only lashes and a fine. He thinks that you pay both, and therefore we see our Mishnah is in fact the opinion of Rabbi Meir, and that's why if ganav tavach on Yom Kippur, even though he gets lashes, he has to pay a fine because that's what Rabbi Meir says. The other sages say you don't get lashes and pay a fine, just like you don't get capital punishment and pay a fine. But Rabbi Meir says, although he agrees that you can't get capital punishment and pay a fine, he thinks that you can get lashes and pay a fine. And so our Mishnah is Rabbi Meir, and we are able to fit this baraita perfectly well if it's talking about the thief that gives it to someone else to do the shechita. But now we ask about that very interpretation. Does it make sense that one person sins and a different person should be liable? In this case, the slaughterer is the one that sinned by slaughtering it. Well, that person is going to be deserving of capital punishment for violating Shabbat. But what doesn't make sense is that the thief should have to pay 4 and 5. We understand if a thief steals a sheep, and then he sells it or slaughters it, then the thief, is going to be liable to 4 and 5. But if he's not the one that slaughtered it, then why should he pay 4 and 5? Amar Rava shane achid amar kera utvacho umecharo ma mechira al yedei acher af tebicha al yedei acher. Rava quotes a pasuk from Shemot. Incidentally, this is a misquote. Utvacho umcharo, the pasuk says o mecharo. And in fact, if you look at the manuscripts, you'll see that yes, in printed editions, that's the top 3 lines are the Vilna, Cincino, and the Venice printed editions. Those two are the earliest printed editions. Read what the Vilna has, and doesn't say the word o, it says umcharo, which is not what we have in the Masoretic text in our Sifrei Torah. But the best manuscripts here, Hamburg and Firenze and Escorial, have the correct O Mechado, although there are two other manuscripts, Ashkenazi manuscripts, that do say the wrong pasuk. And so, yeah, those two. The Vatican was Ashkenazi and Munich is Ashkenazi. But the good manuscripts, you see Hamburg, the Sfaradi manuscript, and this one in Florence have the correct pasuk. And it's in the Vilna edition. It is there is a note on the side that corrects it according to the pasuk as we have it in the Aleppo Codex, in the Masoretic text, and our Sifrei Torah. Okay, in any case, utvacho o mecharo would be the correct reading here. So this case is different because it's comparing them. Just like if you make a sale, you need two parties to make a sale. You can't sell something to yourself. And therefore the owner, the thief, is liable for selling it to another, even though it's someone else that is receiving it. So too, tebicha, even if someone else does the slaughter, the thief is still liable. So while you're right in your question that generally you don't have a case where one person does an action and a different person has to pay the price, that usually doesn't make sense. But in this case, this law is an exception that Rava explains, just like you're selling it with another party, and yet the thief is liable, not the buyer. So too, the thief is liable even if someone else does the slaughtering. The same ruling is derived in two other ways. Instead of comparing utvacho umecharo, maybe the vav here doesn't mean to quote the pasuk, but just means to say, look, it says tevacho and it also says mecharo, and we're comparing them because they're juxtaposed together. But it's clear that the Gemara knows that the word is o, because Rabbi Ishmael says, school Rabbi Ishmael has a braita that says the word o between those two verbs comes to, as extra word, comes to include not only if the thief slaughters it himself, even if he has an agent sell or slaughter the animal, still the thief has to pay 4 and 5. From the school of Rabbi Chizkiah, of Chizkiah, we have a braita that says the word tachat, that you have to pay 5 oxen for the ox and for the sheep. We saw that you don't need both of those tachat words, and so that comes to include a shaliach. That makes sense also. The meaning of tachat means instead of this, instead of that, and so the thief who appoints someone to slaughter it instead of him, nevertheless the thief remains liable. So that takes care of that challenge. Matkif lamor zutra mika midi dilu avid ihu lamichayev aved shaliach umichayev. A similar question, but slightly different. Is there any case where if a person himself would do something, he would not be liable, but if he sends someone else to do it, he would be liable? Right? This is just deepening the question. If the thief himself steals something, an ox, and slaughters it on Shabbat, he is not liable to pay because he gets capital punishment. But if he sends a messenger, then he is liable to pay. So does that make any sense that you should be more lenient on him if he does it himself than if he sends someone else to do it? And the answer to that is evident. Ravashi explains, it's not that the thief is not liable to pay when he himself does it on Shabbat. It's just that we have a rule that you don't give him two punishments. You're already killing him, so then the Bet Din doesn't have a wherewithal to make him pay as well. But if it should be some situation where somehow he gets off of the death penalty, then he does have to pay. In other words, he is theoretically, potentially liable to pay. It's just that practically we're not going to issue that ruling that he has to pay because we're already killing him. But he is liable. He is guilty of it. Okay. All right, now that we solved this whole question for Rabbi Meir, we said the Mishnah's opinion of Rabbi Meir, and the Braita that we brought as a challenge, we were able to explain it away. The Braita says that if you slaughter something on Shabbat, Rabbi Meir says Hayav. Why Chayav? Oh, because he slaughtered it with a messenger. Okay, fine. You got Rabbi Meir off the hook, But now you have to explain the Rabbanan. In that very baraita, say that if the thief, now we're explaining it as through a messenger, gives a messenger the item, the ox to slaughter on Shabbat, then the thief does not have to pay according to Rabbanan. Well, why not? If the slaughterer was someone else and the slaughterer gets capital punishment, then the thief doesn't get capital punishment. So why should the thief not have to pay according to Rabbanan? You gave such a good answer to be Meir. Now we created a problem for Rabbanan. Amri man chachamim Rabbi Shimon damar shechita she'ena reuya lo shema shechita. So we answer, who is chachamim in the Baraita? It is none other than Rabbi Shimon, who says in general, and he even says it in our Mishnah, we're going to come back to a statement in our Mishnah, his general principle is that if you do a ritual slaughter, but it's invalid for whatever reason, is not considered a valid shechita. Meaning that even if someone comes and uses a good knife and he does all the rules of what shechita should be on the neck in the right place, in the right way, but if it doesn't result in kosher meat, in having a valid result, a kosher result, then we don't call that act shechita at all. In the Mishnah, we saw the example, he does shechita, but it turns out to be terefa. That's not, since it's not kosher in the end, so you never did shechita, and you don't have to pay 4 and 5. You only have to pay 4 and 5 if the thief kills an animal through shechita, not if he kills it in any other way. And therefore, in this baraita, for example, it talks about avodah zarah. If you slaughter something for avodah zarah, the meat is not kosher. So even though you did the shechita with 100% the best knife, the best way, you did a perfect shechita, still, that's not called shechita because the meat is not kosher. Shor HaNiskal also, it's not kosher. You can't benefit from its meat, and therefore is not a shechita. And that's why, in that baraita, you don't have to pay. This thief, he gave it to someone else to do shechita, and that person did shechita, but he did it for avodah zarah. Well, that's not considered shechita, and therefore the thief does not have to pay 4 and 5. Good. Amri bishlam avodah zarah v'shor niskal shechita she'ena reuyahi ela Shabbat shechita reuyahi. So that answer makes sense for 2 of the 3 items on the list in that baraita. Avodah zarah and shor niskal, since those things does not produce kosher edible food, therefore it's not called shechita, and the thief does not have to pay 4 and 5 for it. But Shabbat, it is a valid shechita. Ditnan hashochet b'Shabbat u'b'Yom Kippurim af al pi shemitchayev b'nafsho shechitato keshera. We have a Mishnah Masechet Cholin that teaches if someone does shechita on Shabbat or Yom Kippur, even though that's prohibited, and on Shabbat he will be liable to the death penalty for doing shechita on Shabbat. But what about the meat? Can he eat it? Yes, the meat can be eaten, right? They go kill the guy, but then they go make a barbecue. And so the shechita is kosher, and therefore it's a valid shechita. So back to the question, even if you say that this baraita has Rabbi Shimon, right, wouldn't Rabbi Shimon agree that if shechita done on Shabbat, the shechita was done by someone else, not the thief, so the thief is not liable capital punishment, and that shechita is a valid shechita because the meat is kosher and edible, and so since the thief stole and caused it to be slaughtered with the proper ritual slaughter, he should have to pay 4 and 5. How can we explain that case? The answer is Amre Savar Lak Rabbi Yochanan Sandlar. Rabbi Shimon will agree with the other minority opinion of Rabbi Yochanan Sandlar, who thinks that you cannot eat meat that was slaughtered on Shabbat. He disagrees with this Mishnah. Di Tanan Hamevashel b'Shabbat b'shogeg yochal b'mezid lo yochal debred b'meir. Rabbi Yehuda Omer b'shogeg yochal b'moseh Shabbat b'mezid lo yochal olamit. A very important Mishnah in Masechet Tirumot that has practical consequences today. There's 3 opinions about what happens if someone cooks on Shabbat. Can it be eaten? So the first opinion of Rabbi Meir says that if someone cooks on Shabbat by mistake, they didn't realize it was Shabbat, but then now they cooked it, so he can eat the food. But if he did it on purpose, he says, I don't care, it's Shabbat, I want to cook anyway, then there's a penalty. You cooked on Shabbat, via Shabbat, you can't benefit from the item that resulted from violating Shabbat if you did it on purpose, according to the Rabbi Meir. He's the most lenient. Rabbi Yehuda says, if you did it by mistake, then you have to wait till after Shabbat to eat it. You can't benefit on Shabbat itself, so you heated up some water and you cook some soup on Shabbat, and so you can't eat it on Shabbat. After Shabbat, then you can eat it. If you do it on purpose, however, then the person who cooked it cannot eat it forever. Okay, that's the middle opinion of Rabbi Yehuda. Then the most stringent opinion is Rabbi Yochanan HaSandlar Omer, B'shogeg yachel mosei Shabbat lacherim velo lo, b'mezid lo yachel olamit, lo velo la'acherim. He says if someone cooked on Shabbat by mistake, then after Shabbat is over, other people can eat it, but not him, right? I woke up Shabbat morning and I forgot it was Shabbat. I made eggs. So I cannot eat those eggs ever. But after Shabbat, my son can eat the eggs. However, if I did it on purpose, I don't care it was Shabbat, I'm going to violate anyway, then no one can eat those eggs, not ever. Not me and not anybody else. What you see from Rabbi Yochanan is that if you produce something on Shabbat in violation of Shabbat, it's prohibited forever. So the same thing, this is talking about cooking, but the same thing would be true for shechita. Someone does shechita of an animal on Shabbat, he violated Shabbat, and you cannot benefit from the result of an action done on Shabbat is prohibited forever, and therefore it would not be a valid shechita, according to the Bishimon, since it doesn't produce kosher, edible food. It was not shechita. Since it was not shechita, the thief doesn't have to pay 4 and 5. Now, my Tamad Rabbi Yochanan ben Sandlar. Now they mentioned Yochanan. What is his source? Kededarish Rabbi Chia apitcha de ben nesi'ah. Rabbi Chia said this when he was giving a lecture at the entrance to the house of the Nasi. Ushmartem et Shabbat ki kodesh hi lachem. Ma kodesh asu b'achila af maaseh Shabbat asurin b'achila. Since Pasuk in Shemot says that you should observe Shabbat because it is holy to you, so just like something holy, something consecrated, you're not allowed to eat it, so too, something produced in violation of Shabbat, also you are not allowed to eat. Now, if you're going to make a full comparison, then you're going to have a problem, because does that mean that just like something consecrated, you cannot benefit from it, so too, something that's produced in violation of Shabbat would also be prohibited to benefit from? That's why it says kodeshi. It is true, it's kodesh, but it's lachem. You can benefit from it in other ways, you just can't eat it. According to this, it sounds like even if it was done by mistake, it would be like kodesh. So can it be that even b'shogeg, no one is allowed to have it ever? That same pasuk says, those who violate Shabbat and profane Shabbat will get the death penalty. But that's only if you do it on purpose. If you did it by mistake, then that's not true. And that's what Rabbi Yochanan Sandlar said, that if it was done b'shogeg, then after Shabbat, other people can benefit and other people can eat it. So that's the source of him, of Rabbi Yochanan ben Salat, and now we're good. We explain that Baraita according to Bimeir and according to Chachamim. Chachamim is really Bishimon, who happens also has to agree with Rabbi Yochanan HaSandlar. Peligi bar Rav Acha v'Rabina. Chadamar Maseh Shabbat Deoraita. Chadamar Maseh Shabbat Rabbanan. Now that you brought up the subject, in fact, there's a machloket about this, whether something that is produced in violation of Shabbat, what is the level of that prohibition? So Rav Acha and Ravina have a machloket about it. One of them says it's asur midoraita. In fact, you just brought a pasuk from, so that sounds like it's asur midoraita. But another opinion says, no, it's only midrabanan. It's a fine. The rabbis want to gezerah. They don't want you to benefit from, they don't want you to violate Shabbat. So they say, you know what, you can't even benefit from it. And that way, that will be a good reminder and prevent people from violating Shabbat if they know that they can't benefit from it anyway. Now, if you say it's a deoraita prohibition, then we already saw the source. How would the opinion that say that it's only that something that's produced in violation of Shabbat is only prohibited midrabanan? What are they going to do with that pasuk? That pasuk proved that it was prohibited midoraita. So they'll interpret the pasuk differently. They'll say kodesh hi, Shabbat is holy. holy, meaning only Shabbat, the day itself is holy, but something that happens to be produced on Shabbat, that thing is not considered like holy, meaning like something consecrated that will be prohibited. No, it's not. It's permitted. Shabbat is holy, but if you cooked something on Shabbat or did shechita on Shabbat, then that biblically would be permitted. It's only the rabbis that came and made a gezerah about it. So now that we went through this tangent to figure out what the source is for everybody, well, now we have a question back on why we brought this in the first place. According to the one opinion that says that Ma'aseh Shabbat is prohibited mi de'oraita, then everything makes sense because this is the meat is going to be prohibited. Therefore, this is according to the Yochanan Sandlar, and therefore the Shimon would say, since it didn't produce meat, kosher meat that's edible, therefore there was no Ma'aseh Shechita here, and since there was no Shechita done, the thief is not liable according to Rabbanan in that Braita. However, if you follow the other opinion that say that Maaseh Shabbat, something produced on Shabbat, even according to Yochanan Sandlar, is only Masur Mid'Rabbanan. So then on a biblical level, this meat is permitted. So if someone would go and do Shechita on Shabbat, the meat, although midrabanan you can't eat it, midoraita is perfectly kosher, and therefore, according to the Bishimon, on the doraita level, this shechita was a valid shechita. Since it was a valid shechita, and it wasn't the thief himself that did it, it was his friend that did it, so the friend deserves capital punishment, but the thief does not deserve capital punishment, and this is a valid shechita, therefore the thief should be liable 2, 4, and 5, and at what reason would Rabbanan, against Rabbi Meir, to have in our Baraita to say that the thief does not have to pay? Very, very difficult challenge, and in fact, we barely have an answer. Ash'ara, avodah zara, v'shor haniskal. When it says in the Braita that the rabbis say you don't have to pay, they weren't talking about all three cases listed in the Braita, but rather only regarding avodah zara and shor haniskal. In those two cases, when someone slaughters it, since they slaughtered it for avodah zara, or it was an ox that needed to be stoned, these are both prohibited b'hana'ah, and therefore you can't eat it, and therefore the slaughter is not a kosher, it's not a valid slaughter. All right, and we're following the Bishimon. Since there was no shechita, the thief doesn't have to pay 4 and 5. If there was never a shechita, it's the same as just shooting the animal, killing it in a different way. So when the Rabbanan say you don't have to pay, they were only talking about those two cases, but even the rabbis would agree with Rabbi Meir that in the case of Shabbat, that the thief does have to pay. All right, so now we explained the Braita according to Rabbanan, but now we're going to go back to ask a question to Rabbi Meir. Rabbi Meir, amai mechayev shochet la avodah zara, kevan deshachat ba'purta asara, idach isure hana'ahu, vela demare katabach, vela dide katabach. We ask, why does Rabbi Meir say that in the case when the thief stole an ox and then slaughtered it for avodah zara, why should he be liable according to the Rabbi Meir? After all, once he starts slaughtering it just a little bit, just the beginning of the slaughter, the knife just cuts a little bit, already it becomes prohibited behana'ah, because at that point already that's enough to make it an act of idolatry, and therefore it becomes immediately prohibited to have benefit. Something that no one can benefit from has zero value. If something has zero value, has no ownership. Can you own something that is worth zero? Right? Ownership means there's something that's valuable there. So no, I own it. And you say you own it. Okay, we can fight over something, even if it's only worth $1. We can fight over it. But something that is zero value, you can't argue over it. There is no owner. And therefore, when he does a slaughter, he's slaughtering an animal that doesn't belong to its master. And the printed editions, it says here, it doesn't belong to that. He's not slaughtering something that belongs to the master, meaning the original owner from whom the thief stole it, and not of his. Now, actually, it makes no difference if it belongs to him, the thief himself. If it belongs to him, actually, then he also doesn't have to pay. So these words are extraneous. And in fact, if you look at the printed edition, puts it in parentheses, that should be erased. In the early printed editions, the words are there, and they do in fact exist in most manuscripts, but not in the best Sephardic manuscript, the Hamburg one, which does not have those words. So those words probably do not belong there because they don't make sense. The only thing, it's true, it could be added for rhetorical effect. It doesn't belong to him and not to the owner. But the main point is that since it's asur b'hana'ah, there is no owner, and so it doesn't belong to the original owner, and so he's slaughtering, just doing shechita on something. You only have to pay 4 and 5 if you steal and slaughter the animal that belongs to, not to you, but to the original owner. If it doesn't belong to the original owner anymore, then he's not slaughtering that owner's animal, and therefore would not be liable to 4 and 5. So that's all the challenge to the Meir on that case. And the answer, Amar Rava. If you notice, we have Rava in all the editions. It has Rava except for the one that we just said was the best one, Rabbah, it says here. So how could that one have something different than all the others? It could be that Rabbah with a he is an alternate spelling of Rava with an aleph. I know that's very confusing, but that does happen, which makes it exceedingly difficult to figure out 100% whether a statement was said by Rabbah, the 3rd generation Amorah, or his student Rava, the 4th generation Amorah, if even their spelling is interchanged, and that's besides the cases where there's, they get confused. The best way to tell is to see who they're speaking to, but in this case, it's a kind of standalone, so it's hard to know. Anyway, presumably it is Rava, the 4th generation, here. So he says we're talking about a case of where the person said, the thief who's doing the slaughtering said, I want the idolatry to occur only at the end of the slaughter. Even though in the standard case, the beginning of the slaughter is already an act of idolatry, he says, listen, I'm having in mind that the beginning of the slaughter will just be nothing, no significance, and I want this animal to be, I have in mind, this will be a sacrifice to Baal when I finish the slaughter. Since he says that at the finish of the slaughter, while he's slaughtering it, it still is owned. It still has value. It's not asur b'hana'ah yet, and still owned by the original owner, and that's why he's liable to 4 and 5 as a fine. We now ask one more question to Rabbi Meir of this baraita on another case. Shor haniskal isurei hana'aninu lav demareh katabach veladideh katabach. If you have an ox that is meant for, it was already decreed that it needs to be stoned, so it's prohibited to have benefit from it. If you can't have any benefit from it, then it's ownerless, right? Lav b'demareh, it doesn't belong to its original owner, so he's slaughtering something that doesn't belong to the original owner, nor does it belong to the thief himself. It belongs to no one, and since it does not belong to the original owner, the thief is slaughtering something that is not a stolen item anymore. This item itself has no owner, so we shouldn't have to pay 4 and 5. Here we have the same issue textually as we did before, right? The significant thing is that the thief is slaughtering an animal that is not owned by the person he stole it from, right? It doesn't really matter if the thief himself owns it or not. He still would not have to pay 4 and 5. So you don't need this phrase, v'lav dideh tavach. And in fact, if you look at the manuscripts here, again, we see that lav demareh katavach is found in in manuscripts, and actually all of them, v'lav demareh katavach. The phrase lav dideh katavach is found only in the 3 printed editions and in one manuscript, lav didehu, that is not his. In the Vilna edition, it's put in parentheses because I realize it doesn't fit. But you see, in these 4 manuscripts, it only says Since it's prohibited in having any benefit, it does not belong to the original owner, right? And that includes Hamburg, and now Hamburg has lots of friends. Incidentally, Rava is going to answer this question also, and here also in the Hamburg manuscript says Rabbah with a he, joined by the Munich manuscript also that has a he over here. Anyway, back to the answer. Amar Rava, hachav maskinan kigon shemisaro leshomer, fizik bebet shomer, ve'oad bebet shomer, ve'nigmar dino bebet shomer, ve'Rabbi Meir sabar la ke'Rabbi Yaakov, ve'sabar la ke'Rabbi Shimon. So our problem was that why should you be liable according to Rabbi Meir in the case where the thief slaughtered an ox that needs to be stoned? After all, this ox has zero value, and if it has zero value, it has no ownership, and so you shouldn't have to pay for kill. The thief should not have to pay. So the Rava says we're talking about a very specific case of the owner handed his ox to a watchman, to a shomer, and it was a perfectly nice, calm ox at the time. But then, while it was in the shomer's house, it went and killed someone, and it was the witnesses came and testified about it, and it was brought to trial while it was still under the possession of the shomer, and the judge said this needs to be killed. And then that's when the thief stole it. Before they could actually stone this ox, the thief goes and steals it. So why does this make a difference? Because we're also going to add in the opinions of Rabbi Meir, in the opinions of Rabbi Yaakov, Rabbi Meir follows him, and Rabbi Shimon. Well, what do they say? Sabar la Rabbi Yaakov, damar af mishenigmar dino hechiziro shomer labe'alim muchzar. In a normal case, this is already not a normal case, but in a normal case like this, right, I gave my ox to a shomer, and then my ox, while it was there, killed someone, is put on trial, is liable to the death penalty. In that case, normally, it would be killed, right? The Bet Din would come, seize the ox, and stone it, and then the shomer would be liable to pay me the value of the ox. I gave you an ox to watch for me, and I want it back. So he would have to pay the money. However, according to the Yaakov, the shomer can do something smart. Before the Bet Din comes to take the ox, he can return the ox to me. He says, oh, here, you gave me this to watch, I'm returning it. And then they're off the hook, even though this ox is now useless because it's going to be killed in a minute and can have no benefit from it anyway. Nevertheless, he returned the physical item, and so it is considered returned. Furthermore, we're going to add in the Rabbi Shimon. He says that if someone causes a financial loss indirectly, they didn't do it directly to take your money or destroy something, but even they did it just indirectly, nevertheless, that's considered a loss, and one has to pay for it. So in this case, the shomer was planning to take this ox that was sentenced to be stoned, and he was going to return it to the owner and thereby not have to pay. But before he could do that, a thief came, and the thief stole the ox, and now that indirectly caused a loss to the shomer, and now that the shomer now is going to have to pay up out of his pocket for it. So even though this ox is asur b'hana'ah and technically worthless, nevertheless it is worth something to the shomer, because the shomer now is going to have to pay rather than have it. And so here you have a case that even though it's a asur b'hana'ah, nevertheless it actually does have value. And when the thief slaughters it, he is slaughtering something, slaughtering an item that has value to the person that he stole it from, and that's why he does have to pay 4 and 5 for it. Okay, you have to put a lot of things together, but once you do, it's brilliant and it works. Now, just to explain to Rabbi Shimon, where does he say that something indirect you have to pay for? If I have a sacrificial animal that I have responsibility for, I say this here sheep, I am designating this sheep I'm going to bring as a korban olah. Now, if it gets lost or stolen, I have to replace it, so I'm responsible for it. Even though it's consecrated and therefore I can't use it for anything, it doesn't belong to me, it belongs to the Bet HaMikdash. Nevertheless, I'm the one responsible to have to replace it. If a thief would come and steal it, then the thief would have to pay me, according to Rabbi Shimon, right? So if a thief steals kodashim shecher b'cherutan, then the thief is liable to pay 4 and 5. What do you see from that? Even though the thief, normally if the thief steals something consecrated, he doesn't have to pay, because you don't pay 4 and 5 to Gavoa, but he does have to pay me because I'm responsible to replace it. And so there we see even indirect loss, indirect damage, one is liable to pay, and so that's where we see to be Shimon's opinion. Okay, so far so good. Amar Rav Kahana. Rav Kahana says, I repeated the interpretation we had of our Mishnah. Remember, we asked in the Mishnah, how come if the thief slaughters on Yom Kippur, he's patur if he gets lashes, and so he shouldn't have to get lashes and payment? And we answered that the Mishnah is the opinion of Rabbi Meir, who says that you can get lashes and also have to pay. So he repeated this to Rav Zavid from Medinat Yisrael. And Rav Zavid challenged back, wait, can you really say that this Mishnah is only the opinion of Rabbi Meir, who thinks that you can be liable to lashes and payment, and it's not according to the other sages, not according to Rabbi Shimon, who disagrees with that. But after all, the end of our very Mishnah mentions Rabbi Shimon as disagreeing with these two items. Doesn't that imply that he would agree with the rest of the Mishnah? If we look back at the Mishnah, right, we had the case of two sets of witnesses, and then our case of Ganav Umacha b'Shabbat and Tabach b'Yom Kippur. And here, in all these cases, we said he is liable to pay. And then it goes on and brings these cases here of if someone steals and slaughters it, not for eating the meat, but rather for medicine or to feed to the dogs, or if it turns out to be terefa, or it's chulin, he slaughters it in the azara and it's chulin, and all these he has to pay 4 and 5 as well. And then it says Rabbi Shimon exempts bishne elu. He exempts in the last two because those are not ends up being non-kosher meat, and therefore it was not a valid slaughter. If it's not a valid slaughter, you don't have to pay him 4 and 5. It only says that he disagrees with the last two. Doesn't that mean that he agrees with the entire rest of the Mishnah? And that would mean he should agree with Ganav v'Tavach b'Yom Kippurim. So now how can you say, that this is only to be the Meir's opinion and not anybody else's opinion, not Rabbi Shimon? If Rabbi Shimon says here that I only disagree with the last two, doesn't that imply he agrees with the rest of the Mishnah? And we answer, no, he was just saying the last two out of the last 4 mentioned. He says, I say one is not liable for these two, but I would agree with the immediate cases above that you did shechita to get the meat to use it as medicine or to feed to the dogs. In those cases, Rabbi Shimon would agree that he has to pay, but he was not addressing the previous cases on the Mishnah. So in fact, the rest of the Mishnah can be the opinion only of specifically the case of Yom Kippur can be the opinion only of Rabbi Meir. The next part of the Mishnah says, Ganab mishel abiv v'tavach u'machad. If someone steals an ox from his own father and he slaughters it or sells it, and then, so if that was simply the case, of course, he would have to pay his father the 4 or 5 times. But then his father dies before he pays it. And nevertheless, he has to pay 4 and 5. He'll pay it to his father's heirs, his brothers. Now, even though he is one of the heirs too, so he'll get back some of that. But still, he has to pay the proportional amount to the brothers. We're going to bring in this case as a challenge to the following, as a proof. So, but here the question is, if someone stole an animal from two partners that share in an ox, and then this thief stole it, and he slaughters it, and then he goes to partner A and admits. Now the law is, if you admit, then you don't have to pay a fine. So for partner A, he's certainly not going to have to pay anything at all to him. But he did not admit to partner B. Now, how could that be? Once you admit that you stole the animal and it's owned by partners, then isn't that admission that he stole for both of them? The Rishonim discuss different ways that you can concoct such a scenario. He admitted in one court that he stole it from A, but in a different court, he denied that he stole it. Or he denies that B is even a partner at all. He says, no, I own the other half. Okay, so that's the question. Although he's not going to pay a fine to partner A, to whom he admitted, since he denied stealing it from partner B, or did not admit it, then he would have to pay a fine. Can you pay half a fine? Do we say that the pasuk says that if it's an ox, you have to pay 5 oxen? That's what the Torah says, and not 5 halves of an ox. You can't pay a partial fine? Or do we say, yes, it's 5 oxen, that's for a normal case, and if it happens to be that you have to split it, then you can pay 5 halves of an oxen. And if it was with 3 people, then you'd pay, and you admitted to 2 of them, then you'd pay one of them 5/3 of oxen. So which one do we say? And the answer is, in fact, the Torah says 5 has to be 5 whole oxen. You only pay if you pay the entire amount. And so therefore, in our case, where you have no need to pay the entire amount, you would pay to partner B, to whom you did not admit, you'd pay 2.5 oxen to that person. Good. Itibe. But now, Rava has a challenge from our Mishnah. Hold on. In our very Mishnah, where someone steals from his father and slaughters it or sells it, and then his father dies, he has to pay 4 and 5. But this is the same as, once his father dies, this is the same as admitting to one partner and not to another. How is it the same? Let's say the thief has one brother. So now, when he steals and slaughters it, and the father dies, so he has to pay, well, he doesn't have to pay himself, right? Let's say he would pay 5, it's an ox, he would pay 5 to the estate, but then the father, after the father dies, they split the estate, and now the thief would get 2.5, and the brother would get 2.5. So basically, he doesn't have to pay himself, he just has to pay his brother 2.5 oxen. So you see, it's the same thing. This is another case where you'd have to pay, but only a partial payment. And yet our Mishnah says he has to pay the 4 and 5, or the ratio of it, the fraction of it, according to the calculation. If he has 2 brothers, 3 brothers, 10 brothers, so he would have to pay. So you see that there is such thing as a partial payment of 4 and 5, and that goes against what you just said. Rav Nachman answers, we're talking about a case where the father, before he died, already stood trial, and there was already a verdict. Therefore, this does not make a difference. Once a Bet Din makes a verdict, and they say, you have to pay, right, this much, 5 oxen to your father. So then it's a calculation of a certain amount, or you could give oxen, the amount of oxen, and now it just becomes something that you owe, and it doesn't matter what changes after. But in fact, you're right. If it was before the Bet Din made a decision, then they would not be able to make one liable to half of a fine, because, as I said, there's no such thing as half of a fine. So if the father had not been stood trial in court, and the father died, and then the brothers come to court and say, hey, our brother, he's a thief and stole it and he owes us, then the court would say, well, what do you want to pay, half a fine? No such thing as half a fine. But this Mishnah is not talking about that case where the father died first before the trial, but rather where the father himself was there for the trial, and the brother therefore just has to pay the amount. And unrelated to the verdict before, the amount is not going to change after the father died. Okay, so we ask, Aval lo amad bedin mai, so then you're telling me that if the father had not stood trial, then what would be the law? And then you wouldn't have to pay, right? Because you wouldn't make a verdict about a partial payment. But now look at the sefa of the Mishnah, which is coming up in a couple of dapim, that contrasts our Mishnah with a slightly different case. That says if a thief stole from his father, and then his father died, and only after his father died, then he slaughtered or sold the animal, he does not pay 4 and 5 because the owner no longer exists. He slaughtered an animal that actually he has partial ownership of, but in any case, it doesn't belong to the owner because the owner is dead. Now, that's true, but whenever the Mishnah brings two contrasting cases, we always wanted to bring a contrasting case that's as similar as possible to the first one so that you can see the exact point of difference. So rather than switch the order of and say the father's death in this case was before the tabach as opposed to after, you can keep most of the case the same, keep the order the same, that he did tebicha first, and then the father died, and make even a finer distinction, niflog bedideh. When does he have to pay 4 and 5 to the other brothers? When the father already stood trial and the verdict was given. But if the father had not finished the trial and died, and the brothers are the ones bringing him to trial, then he would not, and we could keep the order the same, that he did tabach first and then the father died. Wouldn't that be a better distinction? Amar Nachman says, you're right, hachiname. That would be a finer distinction, but that's not the style of the Mishnah. I did the nesiv resha, gadam mishel aviv betavach umachar, ve'achar kach met aviv, nesiv sefa nameh, gadam mishel aviv umet aviv, ve'achar kach tavach umachar. It wanted to keep a stylistic parallelism, and therefore, since in the beginning it talked about if someone steals from his father and first slaughters it or sells it, and then the father dies, so we wanted to just keep all the words in there, but the same pattern of sentence structure, and just switch the word order and say he stole it from his father, umet aviv, and his father died, and then he slaughtered it and stole it. But you're right, one could have made even that finer distinction. That's what happened when they discussed it on that day. However, they went and slept on it. L'safra amar le chamisha bakar malachamana va'afilu chamisha chaseh bakar. After this discussion on the next day, Rav Nachman came to Rava and says, I changed my mind. Now that I've been thinking about it. The pasuk says you pay 5 oxen, and that means even 5 halves of an oxen, 5 halves of oxen. If it's such a case like with partners, then yes, there is such a thing as a partial payment for a fine. And the reason I didn't say this last night when we were discussing it is because I hadn't eaten ox meat. Okay, what does that have to do with anything? Some people take this literally, that he was fasting that day, or he didn't eat sufficiently that day, and so he didn't have enough nourishment and energy to think through it clearly. He was, if you're hungry, or you didn't eat good food, then you can't think so clearly. Now I had a good breakfast, I had a good sleep. You know what? Now I figured it out. Or it could mean more figuratively. Ox meat is kind of rough, tough to eat. You have to chew it over. It says I didn't chew on it enough. I didn't think about the subject enough. I think it's funny that they're talking about paying an ox, and he's talking about eating an ox. Okay. Anyway, he says I didn't think it through sufficiently. Now that I slept on it, I changed my mind, and I think, yes, there is such a thing as a partial fine. If so, that there's such a thing as a partial fine, then what's the difference between the case in our Mishnah and the next Mishnah regarding a father? If there's partial payment, then how come in our Mishnah, so he steals something from his father and slaughters it, and then the father dies. So why should he not have to pay his brother for half of it? Let's say he has one brother, so pay the brother 5 halves. Why not? Amale resha karina be utbacho kulo beisura sefa la karina be utvacho kulo beisura. The reason is, in the resha we can apply the pasuk that says he stole it and slaughtered it, all in prohibition. Since the father was alive, right, when he slaughtered it, so he steals it from the father, slaughters it. You're not allowed to steal it. You're not allowed to slaughter it. You have to give it back. What are you doing slaughtering something that you just stole? So because both actions were done in prohibition, therefore, and the Resha says he has to pay the 4 and 5, and if he has one brother, then that means he'll pay the brother the half of the fine. Whereas in the Sefa, where he stole it from the father, but then the father died, so then the slaughter does not violate. In fact, he's slaughtering something that doesn't belong to the original owner because the original owner is dead. And so therefore, since the slaughter was not entirely be'isura, because he owns part of it, he's one of the heirs, and so the part that he owns, he's allowed to slaughter. Since it's not entirely in prohibition, therefore you can't say utbacho, that he slaughtered the whole thing in prohibition, and that's why in the sefa he does not have to pay. That explains the difference between the resha and the sefa, assuming that there is such thing as partial payment. Nevertheless, there is still this important difference. Baruch Adonai Leolam, Amen ve'amen.